Okay. Welcome back everyone to session two and this would be the final session where I will be giving you a brief about the task as well as the task where I will be allotting you the task. Those of you who've come from the November, you might already have the task on you. It is just a continuation of that particular task. So it might be a little easier for you. For those of you and the people who've joined from November, please just drop me a text. I need a little help of sorts from you. Um, so please do that. I will just be sharing my screen. Okay. Guys, is my screen visible? Am I visible? Am I audible? Is everything cool? Or is my screen not visible yet? Someone please put it on the chat box or unmute yourself.
Yes, ma'am,
Yes,
you are
you're audible
visible.
and visible.
Great. Thank you. Thank you. Okay. So your task one for the December batch particularly would be drafting of an arbitration award. Now, there are certain things you need to, I would just be giving you a brief about arbitration as a whole for those of you who are still not familiar with the term. For those of you who are, kindly bear with me. Um, and then I would be giving you a brief about the arbitration award, and then I would be handing over a task. Please remember the task would be handed over as a Word document as well as in the form of the PPT. So you'll be having two places where you can find the same problem or task that you need to take care of and that you need to solve and you need to figure it out on your own. A sample would also be sent to you, and if you want, I would be reviewing your tasks as well. So that way you know that you've done it perfectly when you do actually post it on LinkedIn, um, which can sometimes be a very scary place. Sometimes people are very rude and unnecessarily comment on your posting. This might not be the right way to publish it. Hence, we ask all of the tasks to be watermarked with the legal specs. Watermark, so the draft is still yours, but you have the backing of legal specs and nobody will question you as a whole. So that is why, so those are the things you need to be keeping in mind. Moving on with the actual topic, an introduction, just a brief introduction about arbitration. Now, arbitration, the dictionary meaning of arbitration is the process of solving an argument
Progress.
between. Anugraha, please mute yourself. Thank you. The dictionary meaning of arbitration is the process of solving an argument between people by helping them agree to an acceptable situation. And arbitration is a part of the ADRS mechanism, and which benefits the parties who want to avoid the normal lengthy recourse to the local courts for the settlement of dispute. Now, it is a legal technique for the resolution of dispute outside the courts, wherein the parties to a dispute refer to arbitrators whose award they agree to be bound by. Now, so the dictionary meaning of arbitration, as already mentioned, is so I would just be giving you a brief. So arbitration is when there are two parties who have a dispute and who come together, form an agreement, which is known as the arbitration agreement. Arbitration agreement is the basis on which the arbitration dispute go on or are being held. Now, these arbitration disputes are headed by an individual or a group of individuals known as arbitrator or arbitrators. Now, these arbitrators sit upon the dispute and have the parties deliberate amongst themselves, and they are only there to hear and to give their final verdict, which is known as the award. Now, arbitration is a more formal way of the ADRS mechanism. You have certain other mechanisms, which is conciliation, mediation, negotiation, and you also have something known as the Lok Adalat, and you also have your normal like two people just come together, sit, and there'll be one person. So that basically, and when you solve the disputes like that, that is also a kind of ADRS mechanism. Now, ADRS mechanisms are usually employed just for the sole reason that the court proceedings are very lengthy, to say the least, and they are super expensive as well because you need to pay the court, you need to pay the lawyer, you need to pay yourself to be able to come to the court every time the your matter is listed. Now, arbitration specifically is a more formal way of adjudication of disputes outside the court. Now, whereas mediation, negotiation, and conciliation are more informal ways because arbitration has certain procedures that need to be followed and they have certain guidelines that need to be followed. Number one, that there needs to be an arbitration agreement. Number two, it must always end with an arbitral award. And number three, it must always be headed by arbitrators. And number four, there must be two or more parties involved. So these are some things that you need to be keeping in mind before taking your disputes to arbitration. Moving on, there are certain kinds of arbitration. There's ad hoc and there's institutional. Institutional arbitration are is the kind of arbitration where you have an institute or an arbitration institute specifically coming in and helping you resolve your disputes. An ad hoc arbitration is where you choose a person who's not part of an institution but who's an expert in their profession. Now, an arbitrator can be any person ranging from um, retired Supreme Court judges to just someone who is an expert in the subject matter. It varies depending on the party. Moving on. Okay, so there are about 35 arbitral institutions in India at the moment, which are which can be for domestic as well as international. They have PSUs as well as trade and merchant associations, as well as city-specific chambers of commerce and industry. Now, India has 35 arbitral institutions. Um, in Bangalore, we have something known as the Baswangudi Arbitration Center, um, uh, Baswangudi Mediation and Arbitration Center, BMAC, wherein it is an arbitral institution, and we they have matters of domestic as well as international nature being held there. That is something, and also there are city specific as well as state specific chambers of commerce and industry, as well as arbitration institutions which take up matters pertaining to arbitration. Now, that is only pertaining to the institutional arbitration. Ad hoc arbitration, as I already mentioned, it can range from a retired Supreme Court judge and all the way to someone who is an expert in their particular field. Moving on, now the arbitrability of dispute is again there are two cases you can refer to. One is Uttam Singh Duggal versus Union of India, and Booz Allen and Hamilton versus SBI Finance, also known as the Booz Allen case, which specifically talks about arbitrability of disputes. Now, arbitrability of disputes is basically what kind of matters can be sorted out through arbitration. Now, criminal matters, for one, is not arbitrable. Then you have civil wrong, which is not arbitrable. Um, mo- it is mainly pertaining to commercial disputes which are arbitrable. It is pertaining to disputes between the government and an individual or a company which can be arbitrable. It is disputes pertaining to um, it is pertaining to certain other, if you have an arbitration agreement, only the dispute can be arbitrable. If you don't have an arbitration agreement, there are many times where the whole arbitration only cannot happen. Thank you, Karthik. Um, Okay, so these two cases are some things you could refer to. If you need citation for these particular cases, please put up a message on the group, and I would just be sending you the case downloaded directly from STC, or I can send you the citation as well. Um, so. Please refer to these two cases, especially the Booz Allen case, because the Booz Allen case came after the enactment of the Arbitration and Conciliation Act, and the Uttam Singh Dugal was previously enacted before the commencement of the Arbitration and Conciliation Act. So now coming to our topic, which is arbitration award. Now, an arbitration award is basically like a judgment but in the arbitration side of things, like how a judge passes a judgment at the closing of every suit or every case or every proceeding. In the same way, the arbitrator, once he closes the proceedings, he must prepare an award, which is kind of a judgment where he must decide on the issues which are placed before him, and it is okay, he also specifies his decision, and he says that I have been appointed by so and so to say so and so, and that whole thing, what his decision on every dispute is part of the arbitral award. Now, a definition of sorts of the arbitral award is a decision of the arbitral tribunal on the substance of the dispute, and it includes any final, interim, or partial award and any award on cost or interest, but it does not include interlocutory orders. Now, an arbitration award can is usually more often than not the final award which is passed by the arbitral tribunal, but sometimes in certain exceptional circumstances there is also an interim award, which interim basically means during the ongoing of the proceeding, somewhere in the middle, where if a party feels that their rights are not properly taken care of by the arbitrator, they have the they communicate to the arbitrator to pass an interim award. Now the arbitrator feels it's necessary. He does pass an arbitral award. He or she passes an arbitral award, and partial award is again which is not completed, but they've just stopped the proceedings and then they just want an award of that sort. That is also known as a partial award. Now, interlocutory orders are not included in the arbitration award. Moving on, now there are certain essential elements of an arbitral award. There are five. Number one, it must be in writing. Number two, it must be signed by all the arbitrators or members of the arbitral tribunal. It must state the reasons on which the award is based, and it must also specify the date and the place of arbitration. Now, the Arbitration Conciliation Act basically states that after the passing of the award, a signed copy of the award shall be delivered to each party. Now, if the tribunal so requires, or if it feels necessary, can also pass an interim arbitral award. Now, usually the signed copy of the arbitral award is given to both the parties free of cost, unless, of course, it is a very lengthy award. Then if there is an ad hoc arbitrator, he usually charges for it, and if it's an institution, they include it in their miscellaneous cost. Um, Now, moving on, the correction and interpretation of arbitral award is mentioned under Section 33 of the Arbitration and Conciliation Act. It provides that the tribunal may correct or amend the award within 30 days from the receipt of the award. As soon as the parties get the award, the parties as well as the tribunal has 30 days to 30 days for the entire correction and interpretation of the arbitral award to finish. Now, if the tribunal finds the request for correction to be reasonable, then it shall make a correction or interpretation within 30 days of the receipt of request. So basically, you have 60 days, 30 days to basically request for um, 30 days to request for a correction or interpretation, and the tribunal takes 30 another 30 more days to give their response. Now, if the tribunal deems it so necessary, in case it has not been able to sit and deliberate about it, it can extend such period within which it has to make the correction and the interpretation of the award. Moving on, the enforcement of arbitral award. Enforcement is mentioned under Section 36 of the Arbitration and Conciliation Act. provides that if the time for making application to set aside an award under Section 34 has expired or the application has been refused, then the award shall be enforced under the CPC in the same manner as a decree. Now, if one of the parties or both the parties do not um, or if the award is not enforced amongst the both the parties, any one or both the parties can approach the court and they can say that, okay, this is an award which has been passed. This party or both of us are not happy with it. There are two things that can happen. It can either go for appeal or the court can itself pass a decree on it. Now, that usually depends on the parties. Now, if one of the parties are aggrieved, it usually goes for the enforcement, which is under Section 36 of the Act. But if it wants to go on appeal, that is, if one of the parties are not agreeing to the decision, then it can go for appeal as well, which is under Section 37 of the Arbitration and Conciliation Act. The enforcement is basically when, again, any one of the parties does not, properly follow the instructions, and the enforcement is based on on CPC, on the provisions of CPC. So CPC and Arbitration and Conciliation Act goes hand in hand. Now, one second. Okay, sorry. Setting aside of the arbitral award. Now, Section 34 basically provides um, the mechanism for setting aside of an arbitral award. The Act provides a comprehensive list of circumstances under which an arbitral award can be set aside by the court. Now, these are 7 points which I have mentioned. These are the usual points, and then there's another clause which says that any other circumstances where the party feels that there has not been proper um, or at the discretion of the court, the arbitral award can be set aside. Now, the first one is the party is under some incapacity. The arbitration agreement is not valid. There's lack of notice of appointment of arbitrator. The arbitral award deals with disputes not contemplated or not falling within the terms of arbitration, and it contains decisions beyond the scope of the submission of arbitration. The composition of arbitral tribunal was not in accordance with the agreement of the parties, and the court finds that the subject matter of the dispute is not arbitrable, as well as the last one, the award is not in conflict with public policy. Or, sorry, the award is in conflict with public policy. That is when you apply to the court, you apply to the you apply to the high courts. Please keep this in mind. Um, an arbitral award can be set aside or can be appealed only in the high courts and not any other courts which are of lower ranking. Um, so you basically put up an application or put up a plaint under Section 34 of the Arbitration and Conciliation Act before the High Court of whichever state or whichever High Court you want to apply to. That is, and then you mention in all your reasons, etc., etc. You mention the facts, you mention the reasons, you mention what you want the court to do, and then you mention your verification, etc. So that is something you need to keep in mind. Um, Moving on. Okay, so just giving you a brief about the steps that happen in arbitration. So first of all, there must be two parties. There must be an agreement between both the parties. There must be a dispute. Now, these are the preliminary steps to arbitration. Subsequently, once once there's a dispute, you have the initiation of arbitration number one, you have the appointment of arbitrator number two, you have the preliminary meeting number three, then you have the exchanging of statement of claim and response, then you have discovery and inspection, then you have interchange or you give evidence to each other, then you have hearing, then you have submissions, and then you have arguments, and then you have your award. So, and this usually happens in a period, in a very quick manner, in a very fast manner. Usually 2 to 3 steps happen in one go. So, that way there is no delay in the proceeding. So please keep that in. This is the steps which are followed in arbitration. Okay, so now moving on to the task. Now there's an expressway contract. You can change the places according to your will and wish. I have mentioned Hassan and Chitradurga. because I don't know, it just felt right. Okay, so there's an expressway which needs to be constructed. The length of the expressway is 60 kilometers, which will be completed in two phases of 30 kilometers each. Now there is an arbitration clause which has been provided, and during the first phase of the work, the dispute was about the width of the expressway, and ultimately ended up becoming about the payment to the contractor. Now, these are the facts. I would be sending all the facts to you. Uh, yeah, I would be sending you all the facts, and I would be sending you a sample as well. And I would also be sending you an arbitration agreement on the basis of which you need to draft an arbitral award. Now, how do you draft an arbitral award? I would also be sending you the format. So please keep that in mind that there are um, the arbitral tribunal consists of one arbitrator who is a retired Supreme Court judge. Now, the other parties which are present before the arbitral tribunal are the MD and chairman of contractor with his team of advocates and the National Highway Authority of India with its advocates. Keeping this in mind, you need to draft an arbitral award, and your submission date, as I had already mentioned, would be one second, would be on the 9th. Your last date of submission would be on the 9th. And yeah, so that's all about, that's about it for this particular session, this particular task. Now, if one second.